Well, I was going to say that read, R-E-A-D, kind of will
Rip
push
and
into
read. I get it.
read, rip and read.
I get
But
it.
the rip and read has to do with another case that we're all familiar with, Sandra Birchmore. And again, I disclosed that my husband was hired by the civil attorneys, and he's the one who said, that despite what the medical examiner out there had called us, that this was a homicide. Now, he doesn't say who, because that's not what they do. But this was a homicide that kind of broke this case wide open, and we've talked about that before. But as you know, he has now been charged with not only the death of Sandra Birchmore as being a witness in a federal case, but also with the death of her unborn child, which I was waiting for because I was wondering, federal court, what are they? And even though Massachusetts state doesn't have the death penalty, the feds do, and they have until January 21st or 23rd to decide whether or not he gets the death penalty. But in between, there was a motion that was just filed, granted by the court, to go over 20 pages to change venue to New Hampshire. Oh, I'm sorry, to Rhode Island. I apologize. To Rhode Island, where he's presently housed. Okay. He's presently in a Rhode Island penitentiary and has to be transported to Massachusetts, which is one of the reasons why I guess they waive transport on a lot of these hearings. But he wants his case to be tried in federal court in Rhode Island, where he is, instead of in Massachusetts. And that's one thing. Okay. We can talk about that. But in these papers, there's his defense. And his defense is, and you called it, Michael Bryant, not as a baby attorney, but as a good attorney here and as the host of Justice Served TV. His defense is that Michael Morrissey, the Norfolk County DA, has not indicted this as a homicide, that they believe this is a suicide, and he said so, and that the medical examiner for the who's testified for the state, who we've invited on our show to defend her opinion, says it's a suicide. And even though the feds came in with all this other information, still are told me, excuse me, you can tell I forgot to turn off my poker phone. Okay. It still says that this is a suicide. Okay. That's the defense. All right. That's the defense. Rip and read. Oh,
and on the merits of the change of venue, good luck. Good luck with that. The convenience of the defendant and where the defendant is housed, not really going to carry the day, in my opinion.
Yeah, they're saying all the press and the media, but what everybody, the press and media, but you have to find out. You sit there and you try to pick it. Have you heard about this case? You'll be surprised how many people will say they haven't heard about a case.
No, I don't think
Karen Reed.
Yeah, I think, you're right. People will lie. But I think in reality, this is a far less, front page story than many that we have been talking about in Massachusetts. And so
Massachusetts,
I think it's going to be a problem for them to come up with the goods, surveying, because that's why they want the extra briefing pages. In my opinion, they want to be able to submit all kinds of affidavits or some sort of documentation that we can't get a fair trial. Look at all these people that have already made up their minds in this case. It's just a heavy burden, and I don't see it happening.
I don't see it happening either, but you never know. But I don't see it happening. Change of venues are very hard. We had a change of venue in Jason Williams' basketball player case, and that's very unusual because we did all the surveys. And by the way, they cost a lot of money because you have to do all the actual telephone surveys. You got to submit all the articles. If you just rely on articles, in this world, this doesn't do it. You have to have those surveys to show that almost everybody you call says they have heard about the case and they made up their mind. So
again, I predict denied, but who knows? It is
Judge Bryant. We're going to call Judge Bryant. All right, that's my rip and read.
Okay, so now we're going to go from just rip and read to read.
Yeah, there you go.
And I think I'll bring this up so we can move through this probably more quickly than we might some other stuff, just because it's really a narrative that's really well written. I mean, legal pleading aside, which is well done, it's just it's an easy read. I'll put it that way. And yes.
And when we get to there you go, the complaint. Can you go to that introduction there? All right, before the defendants, just go to the introduction. Then we can go back to defendants. I teach this. In federal court. Now this is state court, but in most courts, they don't say you have to do an introduction. I always do an introduction, and I'll tell you why. It's what the judges read. It's what the law clerks read. and that to know what this complaint is about. And once it's almost like the statement to the jury, right? When you're going to try a case, but you're doing it and you're able to frame it your way. So I think we should actually read this introduction, because it becomes really important, because you know what? This is what the press is also going to pick up.
Of course.
This is what this case is about.
And when I looked at it and when I was reading through it, I said, this is a closing argument. That's what this is. This is the closing argument. It's fraught with argument and the alleged facts.
But look at it. Just read this introduction.
Should I read it to myself? No. First of all, you have to remember that you're writing for a particular audience. Any legal writing should be easy. It shouldn't be a pain, a labor. You shouldn't be forcing the reader to figure out what the hell you're doing and where it's coming from. So you set it up with a nice introduction. For 3.5 years, plaintiff Karen Reed was wrongfully accused of homicide and subjected to suspicion, arrest, 2 prosecutions, and public condemnation, all resulting from the gross misconduct of the Massachusetts State Police and those working in tandem with the MSP to shield from liability the party or parties responsible for the death of Boston police officer John O'Keefe III. Now, after being acquitted of all charges relating to Mr. O'Keefe's death, Ms. Reed brings this action to recover for those and address the actions of those actually involved in Mr. O'Keefe's death and the law enforcement officers who abjectly failed to ensure that justice was sought and served in the aftermath of January 29, 2022. So, and then they go into some great detail. I want to look back here at this footnote's important, as we know.
The footnote is really important.
Footnotes are everything.
But just understand that's what this case is about, to recover for her, right? And let me say to you, Alan Jackson, thank you for giving a promo there for Justice Served. It's a well-written complaint, and
I'm sure
and I don't even need to go past page 1 to page 2 with the first paragraph.
Hey, how often do you see a heading complaint with a footnote?
Yeah, no, that's the these 2 footnotes are very important, because
I know they're critical, but you don't usually see it attached to just the header.
Yeah, the plaintiffs are leading off, of course, our favorite person and the text, and there's probably more coming. We know that from the Brian Walsh case.
Oh my gosh.
Michael Proctor in his personal capacity, because that's how you have to plead what is called a civil rights claim. We'll talk about that. You can't sue a state actor usually under a civil rights claim in federal court if you plan to go to federal court, but you sue it under their individual capacity, even though this is filed in state court. We'll talk about that over the weekend with Michael Del Signor, who is an attorney in Boston, who has been our local go-to guy. Sergeant Yuri Buchanan, in his personal capacity. Oh, man, remember that cross. Lieutenant Brian Tully. So he's not going to be able to hide. He's going to be deposed. Then there's Brian Albert, Nicole Albert, Jennifer McCabe, but we'll talk about paragraph 53 on this complaint later on. Matthew McCabe and Brian Higgins, defendants. And then there's a footnote. There you are. There's your footnote. You love it, but it's right after the word defendants.
Yeah.
What is it?
The Massachusetts State Police in town of Canton will be added as defendants after presentment is made pursuant. And this is basically exhausting administrative remedies. They've got to get that done under the Massachusetts law, and then they'll throw them in as well.
Yeah, and that's important, because that's going to bring us to, again, the civil rights, the federal complaints of plea, which are called 42 U.S.C. 1983. And we'll talk about why you can sue individual persons under that when we get to them. But there's also a footnote 2, which over the weekend we'll go more into. And that footnote 2 is... Yeah,
that's this. And this is going to be a very interesting process. And it'll definitely be a question I ask when I'm up there Friday. That is... consolidating cases that are cross-county. They're cross-pollinated. It isn't as simple as they're all in the same venue. They're already, in the same system. Let's just shuffle the deck. No, they've got to bring them into whatever the court may decide is the most appropriate county, right. not just the appropriate way to handle all these cases. And here's something else that there was some.
And that's by the way, is just to remind everybody, what they want to consolidate is the estate of John O'Keefe's complaint, which is in Plymouth County, and this complaint, which is filed in Bristol County.
Exactly. And so one of the things I found interesting was
Bluster.
there's been the bluster of these named defendants to bring a defamation action against Karen Reed and Aidan Carney. Well,
that was all for press. That was all for press. They knew this was coming.
But now what they've done, you know, they probably don't know it because they're not bright, but just file when you answer this complaint, file your cross complaint, counter complaint. I can't remember what they call it in Massachusetts. In California, it'd be California would be a cross complaint. But it's basically their opportunity to raise those affirmative defenses and be proactive for their defamation. There it is. They've been given the entree to this.
They didn't know that they were trying to forestall the media talking about this by saying, we're going to sue everybody, including my client, Aidan Carney, who said, do it, bring it on. I've been telling you to just bring it on.
So be careful what you wish for.